so choose. I will be keeping the clock. You just need to let me know if you want to save some time for rebuttal. And I know this is not an issue in this case, but in our cases, we always try to tell everybody, and this is something for the benefit of the YouTube watchers as well, that are the public that's watching at large. We don't mention victims' names and we don't mention children's names, but that's not the issue in this case. But I just always make sure we say that. Also, if you're not speaking, if you're not the one arguing, I'd ask the attorneys to silence themselves, to mute themselves, so that we don't have any background noise. When you're ready, we're ready to proceed.
Thank you, Your Honor, and may it please the court. Ben Sasse on behalf of Appellants Oberlin College and Dean Meredith Raimondo. I'd like to reserve 5 minutes of my time, please.
That would be fine.
This case stems from student protests urging the Oberlin community to boycott Gibson's Bakery on social justice grounds. The $31 million judgment on appeal includes compensatory and punitive awards for alleged libel in a student flyer and student resolution calling for the boycott, awards for emotional distress allegedly caused by the libel, and a compensatory award for tortious interference with the college's own relationship with the bakery. This court should reverse and enter judgment for Oberlin and its dean. First, the libel claim fails for many reasons, including that the student speech is constitutionally protected opinion and Oberlin did not publish it. Second, the intentional infliction of emotional distress claim fails with the libel claim and because there is no evidence of extreme or outrageous conduct. Third, the tortious interference claim fails because the dean is a party to the college's own relationship with the bakery, and the temporary pause of dining hall food orders did not personally benefit her. Finally, if this court does not enter judgment for Oberlin and its dean, it should at least vacate the punitive damages and attorney fees awards and order a new trial on any remaining claim for actual compensatory damages only. The student protest context is critical here. It has drawn a host of amici because it implicates core First Amendment concerns. It informs both the required analysis and the standard of review, which calls for an independent review of the entire record de novo on all constitutional issues.
Counsel, in regard to that, I'm not sure if you're going to start with your first argument being opinion, but with opinion, it does depend on the totality of the circumstances, doesn't it?
Yes, Your Honor, it does. And I think what I would, where I'd like to go with that, though, is if you look at what their argument is, they cite no authority whatsoever, nor really even any evidence on context. And the trial court, in fact, found that the context was a call for action. Their argument is based solely on the language of the flyer and the resolution. And the point I'd urge you to consider there is the entire reason why the Scott line of cases exists is that even if you were to conclude that the speech is verifiable, that's not enough. Recall that Scott dealt with an allegation of perjury. The court conceded in Scott that the allegation of perjury was verifiable, but it went on to find in Scott that the speech was protected opinion based on context, the fact that it appeared in the sports section of the newspaper. Go to Vail. Vail dealt with allegations of gay bashing, homophobia, and the like. The court said that maybe some of those statements could have been verifiable in other contexts, but in the context of a forum section of a newspaper, the forum section of the newspaper, social convention signals, a reader would be alerted that this is likely an opinion.
But this is not a situation where it's a news media.
No, it's not, Your Honor, but I think this context actually works in our favor. I mean, if you look, and it's not, you don't need news media, right? The George versus Cincinnati Black United Front case we cite dealt with social or civil rights organizations urging a boycott of the city of Cincinnati. And the court there said that the fact that they were urging a boycott and a call to action made allegations of killing, rape, and planting of evidence opinion. Now, if you consider this context, if anything, I think it's an even stronger argument for opinion. As you see in the NAACP's brief, Your Honor, student protests have played a central role in the debate on social justice issues and the exchange of ideas dating back to the 1960s.
But counsel, it's not unlimited either. And everybody agrees to that it's not just because it's dealing with social unrest or civil rights issues or whatever it may be, it's not unlimited speech. There has to be some balancing of it, and the Constitution, provides that it's not going to be completely unlimited. I mean, the case law interpreting the Constitution.
It's not unlimited in the sense that when there's a statement that a reasonable reader would construe as factual and not an opinion, then that's not protected. What I'm suggesting to you here, Your Honor, is that a reasonable observer will conclude that these statements are opinion. And another way to approach this that I think is important here is to recognize the context of where we are. The trial court held that the slander claim failed, okay? Everything that was said at the protest is constitutionally protected speech that has not been appealed. It is now law of the case. What their theory boils down to is the suggestion that what you hear with your ears is protected opinion, but what you see with your eyes in the same moment, at the same place, just by glancing down at the flyer you were handed, while these chants of racism are going on, is somehow factual. And our submission is, under Vail and the other cases that say context matter, that's a line that's illusory and cannot be drawn, and the statement is protected speech.
And I'll let you go after this, and I don't know if the other panel members have any questions, but I guess my point is, if you're looking at context, just like you said, then the context on the written piece of paper could be a completely different context than the verbal demonstration.
In theory, that could be true. In practice, I urge Your Honor to look at both the flyer and resolution themselves and the accompanying email on the resolution. Here, the first and the biggest words on the flyer say "don't buy," which is part and parcel to the boycott and the idea of protected speech. On the back is a place where you look for other places to buy the goods. Any reader who looks at this would not think that it is an objective reporting of facts, which is the test under an opinion. They would assume that the students are expressing their views on social justice issues.
What if you put it together though with the statement that the Gibsons have a long history of racial profiling and racism? Long account, I think the words are.
Right, long account. And I think if you can't verify that whether or not conduct is racist in one instance, then just saying that you could do it over a course of time is no more verifiable. And there's a lot of cases, and again, I would direct you to the NAACP brief, pages 17 through 19, that catalog the cases saying that allegations of racism or discrimination are a point of view and not verifiable. And also, it's important to keep in mind when you mentioned the resolution, Your Honor, that resolution was published by the Student Senate at past 11 o'clock at night with a cover email referring to the National Social Justice Movement and Black Lives Matter. These are not statements that were intended to be facts. They're the students' views on issues that are important to them. And to transition to my second argument, Oberlin did not publish either the flyer or the resolution. The record is...
Publish it by creating it, you're saying?
Publish it by creating it? Publish it under the law, we believe. If you start with the resolution, Oberlin never put the resolution anywhere. There's no evidence that Oberlin ever did anything. In fact, there's no evidence that Oberlin even saw the resolution posted in
the bulletin board.
Yeah, in the students' locked bulletin board at any time before it was taken down. So,
but there is testimony that your dean of students actually did distribute the flyer at the protest.
There is testimony that the dean gave the flyer to a person who she later learned was a reporter. Yes, Your Honor. And I think the required analysis there is distributor liability, as we've argued in our brief under Section 581 of the restatement. And the reason is that that flyer had already been published for over an hour by the students themselves before the dean got a hand on it. And the legal test, if you are publishing something, alleged to have republished something that's already been published or distributed, I would say, is you have to show that the person who distributes the document had reason to know it contained falsehoods at the time she handed it over. And the testimony at trial was the dean had the document for about 2 minutes before she handed it to the reporter. So she didn't even have time to clearly read it, much less formulate an opinion on whether or not the statements in there were true or false. And that's—
But in that in and of itself, couldn't it be argued as negligent at the very least? By distributing a document that you haven't even really looked at to see what it says?
Well, right now, Your Honor, I'm arguing distributor liability. And I would guess what I would urge you to consider there is reason to know, and this is clear in the restatement, is different than should have known. It's not the same test. And so your negligence argument, I don't think flies under the context of distributor liability. It's a different test. And so even if I were to grant you that premise, I would say that under the law, that's not enough to hold that someone has published the document. And then I do want to touch on the intentional interference claim, Your Honor. I think for the reasons I've said, the libel claim falls, and with it, the intentional infliction of emotional distress claim, excuse me. But I think it's also important to recognize that there is absolutely no evidence here of any conduct that rises to the level of extreme or outrageous conduct.
And counsel, you are into your, do you want to save your time, or do you want to continue on with your intentional infliction of emotional distress?
I do want to save my time. Thank you, Your Honor.
Okay, thank you. Attorney Placas? We can't hear you. You're going to have to unmute yourself. Can you unmute yourself, Attorney?
Yeah.
There we go. Oh, excellent. Excellent. Thank you.
I've received help because they understand that I'm a technological idiot. So with that, Your Honor, I'm Lee Placas, and along with my colleague Jackie Bolus-Caldwell, we asked to reserve 3 minutes to allow Ms. Bolus-Caldwell to address the cross appeal. Also, Your Honors, to save time, any reference to Oberlin College will be abbreviated to Oberlin. Your Honors, our tort system is critical to the fabric of our society. It establishes standards of conduct and consequences when individuals or institutions go off the rails. Our civil justice system does not give a free pass to any group or their leaders to destroy property or people's lives just because they are upset or it's expedient to do so. Your Honors, to reverse the judgment below, appellants need to persuade you to do 3 things. Number 1, ignore the record. Number 2, reach beyond the record to inadmissible and unauthenticated stories, almost all of which were not ever properly proffered in the record. And finally, to rewrite the bifurcation statute to save Oberlin from a strategic procedural decision that it chose to preserve. Although this was a long 6-week trial, the legal issues preserved are much simpler than suggested by Oberlin. First of all, they're desperate to turn this into a First Amendment case about student speech. It is not a First Amendment case about student speech.
Well, nonetheless, whether I think I understand your argument, but at the same rate, this is how it all started with student speech, right? At the very least.
Well, Your Honor, it's interesting to note that during a 6-week trial and pretrial proceedings, not one student was ever a defendant, not one student was ever a witness in trial, nor was their testimony ever proffered. Not one student was an affiant in any of the summary judgment proceedings, and that even applies to the 3 students who admitted their crimes. So they're extrapolating and hoping that this background that's not in the record will somehow convert what is a tort case with 3 separate torts into a First Amendment student speech case. This is a tort case, and the First Amendment doesn't eviscerate tort law. And these are 3 separate torts committed by high-ranking Oberlin administrators. Each tort is separately supported by evidence in the record. To highlight that this is a tort case, Your Honors, the parties stipulated on the record, and I quote, Oberlin College agrees that it will be vicariously liable for any verdict entered in any plaintiff's favor against the defendant, Meredith Raimondo. That's in volume 20, page 41. So as we understand what happened in the trial, let's go first to their strategic decision to ask for a bifurcation of the punitive and compensatory phase. So what's the reason and effect for bifurcation? The reason and effect is when you know that there's outrageous conduct that supports malice, that supports punitive damage elements, you want to separate that so that that evidence doesn't come into the compensatory portion of the case. However, once you make that choice, you're stuck with it. And that's exactly what happened in this case. They demanded bifurcation for all three of the torts that resulted in verdicts. The statute doesn't carve out and say, we won't go into the punitive damage phase. If there's compensatory damages, you go into the punitive damage phase. And because this bifurcation statute is relatively new in Ohio law, let's take a look at what it is. It's actually, the punitive damage phase, Your Honor, is actually its own trial. There's opening statements, there's new or additional witness testimony. In fact, in the punitive damage phase in this trial, 5 of Oberlin's high-ranking administrators, including 2 of its presidents, testified. There's direct and cross-examination, and there's introduction of new and additional evidentiary exhibits, and then there's a closing argument directed to the issue of actual malice and punitive damages, and the actual malice was there. So the record supports the compensatory verdicts on each of the 3 torts. With regard
Counsel, let me stop you there, because in the jury interrogatories, it is, I understand your argument that it's 2 separate trials, et cetera, et cetera. But nonetheless, you have the jury interrogatories where there was, the jury found in the actual case on the merits that there was not the statements were not made with falsity or knowingly recklessly disregarding the truth, reckless disregard of the truth. And in the punitive stage, they found that there was the same standard, that was met. I'm just a little confused over that. So I'm trying to get some explanation.
Thank you, Your Honor. In the compensatory phase, Gibson's had 2 avenues available to receive compensatory damages. One was proving by clear and convincing evidence negligence and actual damages, which we did. The alternative, which they didn't need to pursue, was to prove libel actual malice, which would have resulted in presumed damages. We didn't need presumed damages because we had actual damages. So there's no inconsistency in the interrogatories, because in the compensatory damage phase, we received support in the interrogatories for the compensatory damages. Now, there's no inconsistency because these are merely interim interrogatories. This is a unified procedure. The statute requires you go from the compensatory phase into the punitive phase. It was not yet time for us in the compensatory phase to introduce evidence, or more, just as importantly, arguments regarding actual malice. Because had we done that throughout the trial, they would have objected, because we already received an order pursuant to their motion that we weren't allowed to introduce evidence or arguments relevant to the punitive damage phase, which included actual malice. So they got what they asked for, Your Honor. We got the compensatory damage verdict. The case was, there wasn't a final judgment yet. It had to proceed to the second phase. Additional evidence, additional arguments, additional testimony was introduced. And based upon that, the jury was presented with the question that it had to receive as to the elements of the actual libel, actual malice, and punitive damages. And it answered that question. Now, if there was an inconsistency, let's say, gee, there is an inconsistency, what is the proper procedure when there's an apparent or claimed inconsistency in jury interrogatories. You make an objection and you ask the court to reconcile or ask the jury to go back for further proceedings to reconcile. Interestingly enough, that objection was never made. And the court was never asked to reconcile or to have the jury reconcile it because they knew at that time that they were getting exactly what they asked for, 2 separate and independent phases. And in terms of any issue preclusion, there can't be issue preclusion until a judgment is final. And clearly at the first phase of a bifurcated proceeding, it's not a final judgment. So no inconsistency. If there was one, it was waived. The compensatory and punitive verdicts are solid. With regard to intentional infliction of emotional distress, that is, this tort is not dependent upon defamation libel. This tort was based upon the record, Your Honor, of outrageous conduct in the record that occurred when a $1 billion Goliath bullied the Gibsons, threatening to make life difficult and destroying their life's work and future. You've seen a number of examples, obviously demanding special treatment, demanding no prosecution, demanding quid pro quo, demanding that in the future crimes be reported to Oberlin College rather than the police, demanding that there would be a pass in the future for any Oberlin College students who were caught shoplifting the first time. What is that? That's obstruction of justice, that's extortion, that's outrageous. And even when the students admitted in open court with Oberlin College sponsored attorneys at their side, the high-ranking administrator from in the courtroom said, we're gonna rain fire and brimstone on the Gibsons. With regard to tortious interference, clearly we've already briefed that Bon Appetit was not an agent for all the reasons indicated, that because they didn't have authority to bind the Gibsons. With regard to the issues of question of fact or opinion, context is extremely important. It's been briefed. The flyer made factual statements. First of all, part of the flyer charged the commission of a crime. That's defamation per se. With regard to the flyer that says having a long account of racial profiling and discrimination, those are statement of facts that make reference to history. With regard to this post in the display case, it says it's important to share key facts. If the authors themselves say key facts, it's key facts. And it goes on to say has a history of racial profiling and discriminatory treatment.
But when they say key facts, doesn't that go into the idea that the appellant is talking about the context? And then if you look at the remainder of it, when it talks about being a racist establishment and so forth, that's dealing with context, isn't it? In regard to whether it's opinion or not.
Your Honor, I think the jury had a basis to find, and any legal ruling was on solid ground, because when you say it's important to share a few key facts, and you go on to say that these key facts are that there's a history of racial profiling and discriminatory treatment, that meets the necessity of proving that this is fact versus opinion. With regard to publication, again, they ignore the record. She passed out flyers, including to a known reporter, known at that time. He did what reporters do. What do reporters do? They publish this on the front page of the newspaper. She knew it. The testimony is there. Testimony is that she was holding a stack of flyers. She was directing others to distribute the flyers with a bullhorn, Your Honor. As to the post itself, the resolution was posted for over a year in a campus building in which Dean Raimondo, who was also faculty advisor to the Student Senate, had an office 1 floor above the display case in a prominent high traffic position. I know my time is up, so I will exit stage right with the court's permission and allow Jackie Bolus-Caldwell to address our cross appeal. Thank you, Your Honors.
Thank you. I was just getting ready to tell you that. Thank you.
Thank you.
Your Honors, as applied to the unique facts here, the punitive damage statute is unconstitutional because it totally divorces the award of punitive damages from the goals of deterring and punishing, and simply inserts 2 times compensatory damages. And the unique facts: Oberlin is an entity with greater than $1 billion of net worth, and the jury awarded less than 3% of that net worth as a punitive damages award. And Oberlin's net worth is increasing by more than the amount of the punitive damages award each year. Even Oberlin admitted that this was not material. Also critical here, though, is the size of the plaintiff versus the defendant. Here we have a true David and Goliath situation, and how many Davids can ever take on a Goliath and get all the way through trial? Very few. When you have this kind of discrepancy, only meaningful punitive damages can protect society, can protect the welfare, can protect other businesses and individuals in that community. But on these facts, the statute permits Oberlin to look at this case as simply the cost of doing business. And also key is the type of case. This is a libel case where what is at stake is our very reputations. Even Oberlin's president testified that being called a racist is one of the worst things that can happen to a person. And Grandpa Gibson, 90 years old, with tears in his eyes, confided that his greatest fear was going to his grave being labeled a racist. And the conduct was reprehensible. The evidence showed knowing libel and bullying, threats, and extortion. And what was the result? It financially destroyed a thriving 137-year-old bakery and ruined the reputations of David and Grandpa Gibson. On the legal issues, not one of the 3 parts of the rational basis test is met. On these facts, the cap is arbitrary, and on these facts, the cap is unreasonable. The cap removes any rational connection between the defendant's malicious conduct and the defendant's financial wherewithal and deterring and punishing. And there is no real and substantial relationship to the general welfare. It's not enough to say that the cap makes punitive damages predictable. The punitive damages are still predictable on these facts outside of the cap, and only a meaningful cap can protect the general welfare of the community. Here,
But
the
the
statute
caps
itself,
have, excuse me, counsel, the cap, I know you have a little bit of time, but the caps have been upheld as constitutional.
on a facial challenge, but still our applied challenges are still permissible. And in fact, they actually make the general validity of the statute more longer to uphold it on the rare, unique, extreme facts, such as those here. And really, it still is predictable. The very statute itself looks at the smallest employers and defendants and says no greater than 10% of their net worth can ever be a punitive damages award. Here, it's less than 3%. It's predictable, it's fair, and these caps, on these caps, the punitive damage, and on these facts, the punitive damage cap is unconstitutional, and we urge this court to reinstate the punitive damages awarded by the jury.
Thank you very much.
Thank you, Your Honors.
And that's the little bell that says your time is up. All right. Attorney Sasses, are you prepared? Are you ready to go? 5 minutes.
I am. Thank you, Your Honor. I don't have time to go through all my disagreements with the misstatements on the record. What I would encourage the court to do is look at the cites carefully and see what they do and do not support, and also consider that this cruel and bullying tactic mantra is based on internal emails never sent to the Gibsons until discovery in this case. I do want to spend some time, though, touching on a subject that was taking up a bulk of the plaintiff's argument, and that is the bifurcation. And the reason they spend a bulk of their argument on that point is they know that their punitive damages and attorney fees awards are in trouble. And the reason they're in trouble is the jury found 6 separate times that the statements in the flyer and resolution were not published with constitutional actual malice. Now, under Elio, which we have cited, that finding is binding. The trial court had no power to send the issue back to the jury a second time. The waiver mantra is false. Oberlin objected repeatedly to sending the issue back to the jury a second time. And because the trial court had no power to send it back, that first finding is binding here. The case returns to at the point at which error intervened, and that was when the trial court tried to send it back the second time. So the first finding means no punitive damages, no attorney fees awards. And with the rest of the case, that, Your Honor, at least should go back for a new trial on all remaining claims. They say this evidence was hearsay. We did extensive proffers that the evidence went to Oberlin and the dean's state of mind. State of mind evidence is not hearsay under settled law. Oberlin had no ability to tell its side of the story at trial. And to make matters worse, the constitutional actual malice interrogatory at the first phase of trial, Your Honor, was the only one that instructed on truth or falsity, even though the trial court acknowledged in its summary judgment opinion that the negligence standard too required a focus on the truth or falsity of the publications. The trial court, though, over Oberlin's objection, did not tell the jury it had to focus on truth or falsity. That allowed a raft of arguments based on whether Oberlin had to be the so-called adult in the room and other issues having nothing to do with truth or falsity that poisoned the jury and prevented Oberlin from getting a fair trial. And beyond this, you had the aiding and abetting instruction. Your Honor, not only is that an incorrect statement of Ohio law, it's not even civil law. The instruction the trial court gave the jury was a criminal law instruction that badly misled it to find publication based on constitutionally protected speech.
Let me stop you, because this is an important point that I have to ask, as far as I'm concerned anyway. And that is, okay, so let's say the aiding and abetting instruction was incorrect. Okay, how is that harmful, seeing as though there was evidence that the dean actually handed the flyer to people, even if it was just one person?
It is harmful, Your Honor, because they also argued the resolution. They argued that what supported the award was the bullhorn. The bullhorn related to the protest, Your Honor. It had nothing to do with the distribution of the flyer. And by using aiding and abetting, and we cite the Claiborne hardware case for this, what it allowed the plaintiffs to do during closing argument was conflate constitutionally protected protest speech and anything Oberlin did at the protest to make sure they remained safe and lawful with Oberlin's alleged publication of the speech. And the United States Supreme Court is very clear that you have to keep a line between the two, and the aiding and abetting instruction obliterated it. And by the way, on top of that, we have the point I made earlier, Your Honor, about the distributor liability instruction that Oberlin asked for and never gave, and that would have addressed the exact point you made, which is, what is the effect of the handing of the flyer to the reporter? Under the distributor allegation or instruction we asked for, the jury should have been told that there was no publication unless the dean had reason to know at that time. Again, that was a 2-minute period. And as I was indicating before, that's not a negligence standard, Your Honor. That's higher than a negligence standard. And we asked for that instruction and we didn't get it. And so for all of those reasons, we were prejudiced. When you look at, for instance, what they argued the second half of trial.
Counsel, I'm sorry, your 5 minutes is up.
Okay, thank you, Your Honor. We'd request that you reverse.
Thank you, I appreciate that. I wanted to say to both sides, the panel wants to say to both sides, thank you so much for your arguments, your presentations to the court. We will take this matter under advisement and we'll issue a written opinion that will be sent to both sides. And you also, I'm sure, are aware that we release our opinions electronically, so you can look on our website or the Ohio Supreme Court website as well. And I thank you both very much, and I hope that you're able to enjoy now some of the sunshine outside.
Thank you, Your
Honor.
The next oral arguments are scheduled for this Thursday, November 12th. Thank you very much.
Thank you.
Thank you.